It's the appointed time and a formed quorum. There are 3 meetings going on at the same time, and I understand that members will have to attend these other meetings as well. So now let's invite the administration team to join us. In the last meeting held on the 16th of March, there were certain issues to be followed up, as set out at paper CB2 1135/1718 and the government has given us a written response. Please take note of that. And Mr. Peter Shill has written in and to us, and the letter has been distributed to members via email. Mr. Peter Shill has raised certain questions that he raised previously, and also the administration has responded. On the 13th of March, we raised issues, and the government has given us a response. So can I now invite Mr. Fong Ai, Deputy Secretary, to take us through the government's response? We have provided further information to members. I don't have anything special to add here, so we are happy to answer questions of members. The legal advisor would like to say something, please. Thank you, Chairman. On the government's response, as set out in paper number CB-215/1718/02 in relation to paragraphs 3 to 5 on small practice clinics and the relevant exemption. In the last meeting, we asked the administration this. Since the obtaining and the revocation of the exemption, or in relation to the decision, the bill doesn't contain any provision that the aggrieved person can appeal to the Administrative Appeals Board. But our question is, if a person is aggrieved by the decision, whether there is any appeal mechanism for him. And in paragraph 5, the government says that if the person would like to object to a revocation of the exemption, then he would have to, within 14 days, provide additional information to the director for his further consideration. So I would like the government to clarify. In clause 45 here in the bill, there is no categorical provision on this. So if that is the case, should the director's power be specified more clearly? Say if the director has issued this notice of revocation and the relevant person has provided additional information, and after that, does the director have power to extend the 14-day period to consider his appeal? And I also note that, hold on. In relation to Cap 343, the medical clinics ordinance, there is also the mentioning of the fact that a medical clinic can apply for an exemption. And the issuing of exemption or the revocation of exemption under the present legislation, the aggrieved person can make an appeal to the Administrative Appeals Board, and that is set out in section 62 of the AAB Ordinance Cap 442. So it seems to be there seems to be a departure from that in your present bill. So can the administration tell us your rationale? Can I defer to Dr. Chiu to elaborate? Thank you, Dr. Chiu. Under Cap 343, when we talk about exempted medical clinic, under the proposed bill, that is a scheduled clinic. And the clinic, say, can, in accordance with the law, make an appeal to the relevant AAB if the director doesn't issue an exemption. If he doesn't agree to the director's decision, he can make an appeal. And under our bill, such medical clinics do have an appeal mechanism according to the because it is considered a scheduled medical clinic. So the exempted clinic that we talk about here is a small practice clinic, and that is different from the case under CAP 343. And if the director believes that the clinic doesn't fall into the definition of small practice clinic, an exemption will not be given. But then that doesn't rule out the fact that the small practice clinic can lodge an application to apply for a license. So it's different from the scenario under CAP 343 because we're talking about two different types of medical clinics. Any further questions from members? So when we get to that part of the bill, then we can discuss this further. And last time, we were up to sections or clause 63. We will start from clause 64. Mr. Peter Shiu, are you going to ask a question or do you want to talk about clause 64? So let me start first, and then if you have further questions, you can raise them afterwards. So can the government take us through section or clause 64, please? Mr. Lee. Thank you, Chairman. Division 5, Part 5, that comprises clauses 64 and 65. And that is to say, the public-private healthcare facility has certain responsibilities in handling complaints. And 64, the licensee of a private healthcare facility must put in place a complaints handling procedure for receiving and responding to complaints that are received against the facility. That is clause 64. Mr. Peter Shiu. Chairman, I will give you 4 minutes. Chairman, I earlier tabled this document, and I would like to say something about this. Now, in the main, it is about this. In the full sitting, there is a question raised on the fact that there are inadequate doctors. So I'm asking about the ratio of doctors in Hong Kong. The government's response is that for every 1,000 people in Hong Kong, there are 1.9 doctors. And what about the overseas practice? Singapore, South Korea, Japan, US, etc. The doctor-to-patient ratio is much higher than that in Hong Kong. And Hong Kong has a lowest ratio. Why did I raise this question? Because for this bill, in future, the doctors have to oversee the clinics. So if a doctor is responsible for taking care of 2 to 3 clinics, then the number of doctors would not be able to cope, because if the clinics are also to work with the beauty salons, and there is even a higher demand for doctors. So as a result, there will be fewer doctors working in the public healthcare system. So since we don't have enough doctors, should we allow more doctors to take care of more clinics? And some people may be worried that if a doctor oversees a number of clinics, many clinics, and would that be a problem? But I understand that the doctor's duties is to make sure that the clinic is in compliance with the law, it is hygienic, and so on. So all the doctors need to do is to visit the clinic once a week. And sometimes people worry that if the doctors are not there, then that won't do any good to patients. But there are so many medical procedures which entail the doctor's service. Maybe doctors are obliged to carry out certain procedures, and his duties in those parts cannot be replaced by others. So if a clinic provide, say, beauty services or massaging services, then we don't need the presence of a doctor. So the doctor doesn't have to be at the clinic for a long time. So I hope that the government can relax on the requirements on the number of clinics that the doctor should look after. In page 8 of In paragraph 8 of the response, the government has said that it is considering relaxing the requirement for the doctor to take charge of at most 3 clinics. We haven't come to that part of the bill yet. Maybe we can further discuss that when we come to that part of the bill. In any case, I will ask the administration to respond first. I think when we come to that particular part of the bill, we can discuss in greater detail. In any case, let's ask the DS to respond first. Thank you, Mr. Peter Shou, for your concern. In June last year, we released a manpower needs report, and we did see that in the long term, there are insufficient doctors in Hong Kong. But the shortage really is within the public healthcare system. And in the past 10 years, actually, we've been increasing the number of university places from doctors from 250 to 440.
So we hope that there can be more than 2,000 doctors joining the HA. So to a certain extent, the public hospital shortage can be alleviated. So in our bill, 1 doctor acting as CME can supervise 2 clinics, and we are now considering the industry concerns. Can we increase it to 3 clinics? So we are looking into that, but we feel that to a certain extent, if we require the CME to supervise the daily operations effectively, then 1 person acting as CME for 3 clinics is actually quite a lot. But we do understand members' concerns. I just want to respond that even increasing it to 3 clinics, it's insufficient. I understand that there are going to be more medical graduates, but the number of elderly, the aging population, is going to grow much quicker. So the future demand is going to be much greater. So if you do not relax the limit, there's no way we can go back. Next we have Mr. Kokake. I have read the government's response, and I'm still concerned. Why do we have the requirement of a CME and calls for relaxation? It's because we want to ensure that in the private healthcare facilities or clinics, we have sufficient accountability. And I see there are some loopholes in current legislation. For example, in pharmacies, you are aware that registered pharmacists, sometimes they don't need to be full-time at the pharmacy. They can spend a certain amount of time per day at the pharmacy, and this practice gives rise to a lot of loopholes. So in the future, if the healthcare facilities requirements are relaxed, the government has to be very careful. You need statistics. Let's say the healthcare facility, if they have a fixed number of medical procedures there, it's barely adequate to have 1 CME. So if it's just a nominal facility, they are facing 1 doctor is facing 100 patients. But as long as what happens if we have 1 accident? If there's 1 incident, well, who's going to bear the responsibility? The bill wants to safeguard consumers, clients, patients, or whatever you call them. The government needs to be careful. We cannot relax this because otherwise it would be meaningless. If 1 person can supervise many daycare facilities, we're not just talking about medical procedures being cosmetic procedures. So I hope that we don't bring down the standards. Now, if the government wishes to further relax the number of facilities the CME can supervise unless they can tell us very clearly that there are certain standards. Why do we relax it? Is it because of workload, the so-called healthcare facility? How much risks are they undertaking? We need reasons to convince us why it has to be relaxed. Otherwise, it would be prone to accidents. If we have a very busy practice, it needs one person full-time. If you relax that threshold, I don't know how you can prevent disasters. Secretary, I agree with Mr. Kwok's concern. In our bill, we state very clearly that a person can only supervise 2 daycare centers or 2 clinics because the daycare facility has a higher risk. We don't want to relax us any further. We're just talking about the general clinics, and there might be some room there, and we want to see if there is any room for further relaxation. But ultimately, the utmost concern is patient safety, that is risk control. So if they undertake procedures, and I mean medical procedures that carry risks, it might be an invasive procedure. So are you going to consider them as clinics? Well, according to our bill, Schedule 2, we have a series of procedures listed. So as if they fall into that, then it can only be undertaken by a private hospital or a daycare center. Well, first of all, the schedule needs to be updated frequently. Otherwise, when we have new procedures, there's no way you can catch up. You cannot protect consumer safety. So can that mechanism be enshrined in the bill? Could you respond? Well, why do we have a schedule to list the procedures? It's because we can update that. How frequently will you do it? Well, first, we need to implement. We have to see the operations of the 500 healthcare facilities, and we will conduct a review at an appropriate moment. We have to consider what would be a reasonable review period. I have a question regarding Clause 64, the one we're scrutinizing. The question was about the CME, and I think we can have further discussions in the CSAs. We're talking about the procedures. So the licensee needs to ensure that there's a suitable method for the complainant to check the progress of the complaint. So do we require the medical centers to provide a complaint mechanism, and what is the complaint methodology? Will that be displayed, and what is an appropriate method of conveying that message? Well, in our practice guideline, we will list that. Essentially, in CAP 165 and 343, we require them to display the complaint mechanism for the public and patients. I was referring to display method. Are you going to include it in the email, WhatsApp, or is there any methodology? Does it have to be in a highly visible area? Yes, it has to be in a visible area, highly visible area, but we don't have a fixed requirement. When we inspect the facilities, we will see whether their practice is appropriate. As a matter of fact, a lot of times the patients might not have an email, but some institutions might want to avoid complaints, and they just leave an email address. Okay, any further questions on Clause 64? Ms. Zhang Laiwan. Thank you, Chairman. I want to return to my favorite question. Clause 64 is about complaint handling procedures. So the licensee needs to set up a complaint mechanism. They have to have a complaint handling procedure for receiving, managing, and responding to complaints. And the licensee can be an individual or a partnership, a company, a limited company. It could even be an organization. But in the paper, I don't understand. So let's say a person lodges a complaint. So the complaint, is it addressed to the licensee? It's a body corporate. It's not an individual, a Mr. or a lady. So they are addressing a certain company. So who is going to be on the receiving end of that complaint? Yes, I can provide some more details. For example, in CAP 165, we have a practice guideline, and we have a section dealing with complaints. The relevant institute needs to have a mechanism for patients or patients' representative to make a complaint. It even requires them to state clearly that what's the time limit for the preliminary response. For example, they might need to respond in 10 days. The chairman also raised the question, where do they notify the patient or the caregivers of this complaint mechanism? Maybe in the registration, the cashier, the lobby, they have to convey this message. We also require them to have a designated patient communication patient manager. So when they receive complaints, we require them to keep records. The Department of Health requires them to refer the complaints to us, and during inspections we can see whether complaints were dealt with appropriately. And we also require them to do training. So in our practice guideline, we will describe that in detail. Well, Chairman, you still haven't answered to whom the letter will be addressed. Well, that is a large change, and I need to state that in the past, when we go to clinics to visit doctors, the clinics, the small medical facilities will have a label, Dr. So-and-so, and that is a matter of trustworthiness. The doctor has been in practice so long, his reputation as a doctor has been established. But now if we convert it into a company, and you are running a company, then there are some problems. Because if we run a business, well, whether we do business with a company, we have to check the company's credit. And even if before I issue an LC, I can get some information from banks. There's a lot of information you can get. But we are now talking about a healthcare facility. It's a business, but the CME is just an employee, but the licensee's background and so on, it's obscure. So if incidents occur, who is accountable? The licensee can also be an association. So there's there is no compensation. So for what safeguards protection do we have for the public and clients? Well, we have other members with questions, so perhaps the government could respond, and then we'll move on to the next question. Dr. Chiu? Well, regarding members' questions, there are two areas. Complaints against the doctor. It can be dealt with by the medical council, but if you are dealing with the premises require a license, then you'd have to address the licensee, and as we said just now, we also require the institute to have a patient relations manager or a CME.
So no matter to whom the letter is sent to, the licensee and of the premises must deal with the complaint and give an account to the Department of Health. If the letter is addressed to the patient's relation officer, the licensee has the responsibility to deal with the complaint. Dr. Annan Zhang was asking about a scenario where the licensee is an NGO or company limited. So maybe these two types of parties will not be able to be held liable. So how do you make of that kind of scenario? Dr. Chiu, to us, we would be holding the licensee accountable all the time. If it is not a hospital, it can be an individual, then that individual should bear the responsibility. And under our bill, we also said that the directors would also have to be held reliable as well. So if they are breaching the code of practice, then if the institution is not complying with our requirements and the code of practice, then the licensee has to be held accountable. So Dr. Zhang, if you want to follow up further, wait for the next round. Dr. Helena Wong. Chairman, I would like to ask about the complaint handling mechanism. As mentioned just now, if you want to complain against individuals in the PHF, then you should go to the Medical Council of Hong Kong. It will not be dealt with the complaints committee in this bill, right? Mr. Fong or Mr. Lee? Thank you, Chairman, and thank you, Dr. Wong, for your questions. A person may complain against the facility on several aspects. If the professionalism is involved, then Dr. Wong is right. You may complain to the MCHK. But then sometimes the complaints also involve whether the facilities are doing an adequate job. So we think that the PHF should establish a complaint handling mechanism itself. The PHF will be looking into the complaints themselves to see whether the complaints should be substantiated or not. You said that the report of the investigation has to be kept, records have to be kept, evidence has to be kept, and the DH can check on them. So I have several questions on this part. First, will the investigation report be made public, or it is only made known to the complainants only? Second, if the complainant doesn't accept the investigation report, is there an appeal mechanism for him? And who will deal with such appeals? And what about the role of the DH in all these? So I think we will go on to discuss this when we come to the next part. Anyway, please give her a brief response. The investigation results will be made known to the complainant. And if the complainant is not happy with the results, and then He can take it to the complaints committee as set out in clause 65. It is an independent committee. So, Chairman, you have to notify the complainant. But then if these are serious incidents where public interest and public concern is involved, will the investigation reports be made public? Or is it the case that in whatever circumstances may it be, only the complainant will be notified? Dr. Chiu, thank you for the member for his questions. Our existing practice is that if individuals make a complaint, we will make a reply because privacy issues are at stake. And if the DH conducts investigation and we found that, say, public health risk is involved, and in accordance with our enforcement power, we will deal with these cases appropriately. If there are major incidents involving public health, or maybe there are certain risks are involved. Maybe we go to inspect certain clinics and we found that the temperature for in the storage for the vaccines is not right. We will issue a press release. Well, we will look at the individual circumstances, but as far as individual complaints are concerned, we will first notify the individual complainants. I have another question. If the relevant PHF have not kept records as requested and maybe willfully destroy certain reports and evidence, should they be held criminally liable? Dr. Chiu, if they don't keep records, then they may possibly breach the code of practice. And if the code of practice is breached under the bill, their license maybe it's at stake. We may issue warnings and we may also suspend the license. Does it mean that there is no criminal liability? The only option that you would take is to suspend the license. If the code of practice is breached, then it will have an impact on the license. But then if that person does something dishonest, maybe he is blocking our law enforcement action, then under the bill, well, this person may be held criminally liable. Does the code of practice have any legal effect? Does it carry the same legal effect as the ordinance itself? Mr. Lee. Thank you, Dr. Wong, for your question. In section or clause 64 of the bill, it sets out clearly that there should be a summaries of the complaints handled and records should be kept. If they don't do that, then they are already breaching the law. And of course, under the code of practice, there are detailed requirements on how the records should be kept. If they don't do that, they are breaching not only the code of practice, but also the law itself. And the code of practice is drawn up based on the law. And later on, we will talk about the fact that DH will have the power to issue code of practice under the bill. So what he does may already have breached as clause 64, and that means that the Director of Health can take enforcement action and revoke the license of the person concerned. Mr. Tommy Zhang, I know that I came in late, but I would like to talk about the government's paper, CB bracket 21135/178 bracket 02, which is a response to our issues raised at the meeting on the 16th of March. In paragraph 11, they seem to be responding to our questions. Well, I would rather you not respond at all if you gave me an answer like that. I think you are just scratching the surface of the problem. Are you trying to evade the issue and thinking that I will not be here today? Now, last time when we discussed clauses 61 to 63 on pricing, we talk about price transparency all the time, but to me, last time you explained how you're making sure that there is price transparency. you are talking about not an average figure, some ranges you've been talking about. Some doctors may charge 1,200, the others 6,000. You gave us a range, and then you consider that as a transparent approach. Now it's from a range from $1,000 to $6,000. But then there may be dozens of doctors in a hospital. You may give me a range, but then when I approach a certain doctor, then I would not know exactly the fees to be charged. And you gave us a range as wide as $1,000 to $6,000. So last time I asked, now since you are asking that there is price transparency on the part of hospitals, should the hospitals be required to list out the different fees charged by the different doctors? Don't tell me about the average statistics and then consider it as price transparency. You may talk about the fees to be charged for an operating theater, and you may also give us the fees for the private ward, private ward, general ward, etc. That's one issue. But then when it comes to doctors, the anesthesiast, and they may be charging us, and in paragraph 11 of your response, I think you are just repeating what you said the other day. You didn't answer the questions raised by many members, including myself. We've asked that you work on it further, but you didn't do it. Maybe you told us, you will tell us that there will be a subsidiary legislation that will give out all the details. But why don't you set out things clearly here? Last time I said that my colleagues, some of my colleagues would go to private hospitals to practice. And Dr. Leung Ka-Lau, he was making a lot when he joined the private sector. Back then, before that, he was working in the public hospital. In any case, I think it's impossible to see that while the same service is being provided, but the fees differ because I live in a different ward. Now, when I have a surgery in an operating theater, I use the same operating bed. But then how come that I live in a first-class ward? I would be paying a 20 or 30% more, and when I live in a second-class ward, then I'm charged much more cheaply. I don't know why the middle class in Hong Kong are complaining about this all the time. And also when the doctors are making rounds in the wards, how come that I'm live in a first-class ward and I'm charged a higher fee, and for the general, if I live in a general ward, I'm charged much less? Well, in fact, for a doctor, it's easier for him to make rounds in a first-class ward because it's less congested. So I don't get it. Why that you have this bill and you said or you claim that there will be price transparency, and you are happy just to have a range specified, and you are not setting out the individual fees charged by the individual doctors. And then maybe we are paying 30% more, 50% more just because we live in a certain ward. Please try to explain why this is the case. All right, well, let's hear from the administration before you queue for a second round. Deputy Secretary, Mr. Fong, I understand Mr. Zhang's concern. The bill has not taken effect, but then we have talked to the Private Hospitals Association, and they told us that they would come up with a budget estimate for the individual patients, and all the doctor's fees will be listed in that budget. estimate. Now, depending on the complexity of the case, maybe the budget will be exceeded ultimately. But in any case, they have to present the patients with a budget estimate that will cover all the hospital charges, miscellaneous charges, and doctor's fees, etc. And the private hospitals are putting that in place progressively. So, and for their price list, the hospitals have also given a full list of the items to be charged by the resident doctors. But then for doctors who are not the resident doctors who are serving the patients there, it's difficult to ask them for a detailed list of the fees they charged. Now, the price lists have been uploaded onto the websites of the hospitals. I myself visited the websites and did comparison myself, and I understand Mr. Zhang's concern. There are differences in the, say, the costs or the price for doctors to make rounds in the wards depending on the type of wards. And I've noted that, and I've talked to the Private Hospitals Association. I've talked to 12 private hospitals on price transparency.
And I have highlighted this topic for discussion, and we do need to explore further. This fee structure, whether it is up to date, we are in a discussion, so we hope that we have a communication with the private hospital union, and of course we cannot underestimate the complexity. They have been using this practice for so long, and we do need discussion if we want to review that practice. And we will continue to liaise with the Private Hospital Association. Thank you, Chairman. Next, Ms. Zhang Laiwan. Chairman, the question I just asked has not been answered satisfactorily, and I would like to pursue it from a different perspective. The government said that if there are complaints, medical complaints, incident complaints, or whatever, the doctor involved might be sent to be dealt with by the medical council. So I want to ask, the doctor's reputation, career would be affected, but the doctor's relationship with the clinic and licensee, it's sort of like an employee-employer relationship, especially for young doctors. So I want to understand the doctors under this new regime. The doctor still needs to purchase indemnity insurance, but the licensee is not required, and the licensee is a company. Let me respond to some general principles. I understand Ms. Zhang's concern. That is, who would be accountable. Now, regarding the doctor, they have a professional ethic and standards. If there's a professional misconduct, the patient can take it to the medical council. But if it involves the whole private doctor, the private hospital, the healthcare facility, the daycare center, whether there have been some management problems, or the doctor has acted appropriately, so the institute needs to conduct investigation and respond to the complainant. That is what we require of them. But the doctor will have purchased professional indemnity insurance, and we believe that the relevant private hospitals, the clinics, and the healthcare facilities would have purchased relevant insurance. They are also, is it mandatory? It's not the bill requirement, but in fact they are already doing that. And let me defer to Dr. Chu. Dr. Chu? Thank you, Chairman. I think we are talking about premises and who is responsible. Under the bill, first of all, the licensee has their responsibilities. Clause 47 has listed that they are responsible for the whole institute, the operations, the care for patients, and so on. So, aside from the licensee, we also have a CME, the Chief Medical Officer executive also has to deal with the daily management, and they have to maintain quality standards. So that is another addition to our quality control. So the CME for new doctors under this bill, they need 4 years experience before they can act as a CME for the clinic. And the third party, let's say for dentists, for their professional conduct and practice, they would have to answer to medical counsel and dental counsel. So typically in a clinic, that's how they operate. In private hospitals, we require an extra. There is a medical consultative committee, and they look at the quality of care. So even if we don't call it by that name, the private hospitals have a similar corporate organization. So if the service provider service is questionable, we require the private hospitals, we require their own committee to look into it regarding the provision of services, whether their staff need improving their service standards. So there are several different layers of protection and different people responsible for different areas. Thank you. Chairman, we have a lot of centers now. They require the patients to sign liability agreements. So these licensees, can they ask patients to sign these? We do not require them. Well, if they have signed a liability agreement, then they are not responsible for anything. We have to look at the code of practice. Ms. Jiang's question was, if a medical institution, they don't want to bear any responsibilities, and they require patients to sign a disclaimer, and there's no means to pursue it, so that gives people a loophole. Can they do that? Well, you have to understand, Chairman, that doctors won't ask you to do that. They have their reputation at stake, but if it's a company, they are responsible. We do have other people in the queue, so let's have a brief response. Mr. Lee? Thank you, Ms. Jiang. And I think the medical institution, if they ask patients to sign forms, they want the patients to understand the risks involved in the procedures. So usually we call it consent forms. Now, does it allow for a waiver of liability? Well, if the terms are unreasonable, so when it goes to the civil court, I don't think they can become totally not liable. We also have Mr. Wan Siu-kin. Regarding clause 64, I have a few questions. In 64 bracket 1, it mentions a private healthcare facility complaint handling procedure. So is it going to be interpreted according to the different facilities, or do we have a standard procedure? I had mentioned that once, and we will ask the Institute to describe a complaint procedure. Put simply, they need a mechanism. They need to have a patient relation manager. They have to outline their complaint procedure, and it has to be displayed in a visible area at the cashier, at the check-in counter. They also have to state typically how long it will take for a response. We also require that the complaint have to be recorded, archived, and if necessary, Department of Health can inspect that information. I want to ask, in 64 bracket 4, there are a series of requirements, and the wording says that the director can require the facility to provide certain information such as complaints against the facility and so on. Well, why does it say summary? Why can't we have a full report? Or wouldn't it be more effective supervision if we have a full report? Well, put simply, if we have a complaint currently or in the future, there's a complaint at the Institute itself, and we have a future complaint to committee or the Department of Health. Now, handling complaints, we mentioned that there is a matter of privacy. If they don't have a consent form, they shouldn't submit the confidential information to us. So if the complaint doesn't come to the DH, they handle it themselves, or we just ask for a summary. So the current practice is we look at the summary, how they handled the complaint. If we feel it's necessary to follow up, we will ask the hospital for the information. If necessary, we will even inspect ourselves. Chairman, that doesn't satisfy my curiosity, Chairman. First of all, I think there is some confidentiality regarding summaries. And second, if we have legal power, I don't see how it is related to privacy. Now, if we have a medical report submitted to the Director of Health, or why do we just have a summary? A lot of important information is not included. I would like you to reconsider. Thank you, Chairman. Thank you for the question. Just now, Dr. Chiu mentioned 2 layers. The private healthcare facility, if they handled the complaint and the complainant is satisfied, then essentially the matter is resolved if the patient is satisfied or the complainant is satisfied. So the Department of Health would also require the medical facilities to maintain archives and a summary whether the complaint was resolved satisfactorily or not. But when the complainant is not satisfied, they can take the complaint to another independent complaint committee. So at that stage, they can provide further consent, and we can deal with it in greater detail. So that is a more effective and resource efficient procedure. Ms. Helena Wong. I am concerned about private hospital fees. Now, historically, the fees are in proportion to the ward, and that is information that is hard for patients to ascertain and also budget for. I think the bill needs to deal with this directly. I have recently visited a private hospital to visit a friend. They are in a first-class ward. It's a private room. They have independent washroom facilities. I asked how much the room was. $1,700 per day, and I said that's a good deal. You have hotel facilities, but then she said that I don't know how to. The room is $1,700, but every few days somebody asks you to sign a bill, and it added up to hundreds of thousands. You have to pay hundreds of thousands every few days. And so we don't want complaints about fee structure. So if you don't state that we have to decouple the medical fees from the ward fees, we have to calculate independently, and you should not correlate that with a private room, a double room, or a general ward, and so otherwise you are giving private hospitals too much room to overcharge. Because if you're in a private room, just a cotton swab would cost different. The medication for kidney dialysis would be different depending on the ward. So the fee structure table, you have no way to ascertain how much inflation is occurring. So if we cannot deal with that in this bill, that if you don't de-link medical services from the ward fee, they cannot comply with the licensing regime. The government needs to deal with that. Otherwise, the Democratic Party and I think the Liberal Party will have to look at CSAs.
On the question of pricing, I think it takes more time for us to discuss and consider it. And in fact, in the last meeting, we spent a lot of time discussing pricing. And two members today are also very concerned about this matter. So if there is more time for us to exchange views, then that will help. So please ask the administration to answer whether they will seriously consider our suggestion. Well, I will give them sufficient time to respond. I just want to talk about how this matter should be dealt with, because Mr. Chao Mi-chang has spent half an hour last time and chasing up on this particular subject matter. So on this particular topic, maybe after the meeting, the administration can meet with the members who are concerned about pricing. So, and then we can have in-depth discussions. We can talk about the pros and cons and consider the overall picture to make sure that what we propose is appropriate and effective. So can the administration agree to that suggestion? And if this is being done, I hope that Mr. Chao Mi-chang and Dr. Helena Wong and myself can attend such a meeting. So on Dr. Wong's question, maybe you can respond. Mr. Fong. Thank you, Chairman. Thank you, Dr. Wong, for your question. On the price structure, Dr. Helena Wong has raised some concerns. And as I said before, it is one of our concerns as well, and we're looking at it. We understand that the private hospitals have adopted a fee structure which is related to the type of ward all along. As I said, we have talked to the Private Hospitals Association, 12 private hospitals on this, and we will continue to have a dialogue with them. So you will continue discussing it with them, but it's a matter of whether they're willing to accept your proposal. So if they accept our proposal, then that can be written into the bill. If they're not willing to accept, then you will never get it included in the bill, right? I understand the members' concern. While the pricing is a very complex issue, and it's not a straightforward matter, and it cannot be written easily into the bill itself. We need full discussion on what is the best approach, and we think that we must discuss with the relevant stakeholders first before mapping the way forward. And I would agree to the chairman suggested just now that outside of this bills committee meeting, we can talk to the members concerned to see how we should follow up on this. We need detailed discussion on this before we can come up with practices which are acceptable to all sides, including the public. Now, the relevant stakeholders include the patients. If you just listen to the private hospitals, of course, they don't want to introduce any changes because they aim at making profit. Maybe I have missed saying something, saying that patients are also the relevant stakeholders. That's right. In fact, several members have given their views with very good reasons too. And can we, say, deal with the pricing issue separately and how it will affect the market? We must conduct some assessment. Will we actually be passing on the cost associated with the first-class ward onto, say, the second-class or the general wards? We need to have a thorough discussions on that. Chairman, I am not concerned about whether they are going to pass on the cost to some other wards. Ask them to pass the cost to Tommy Zhang. Well, I would not listen to you. I know how to make comparisons of the quotations myself. The focus should be on this. On what basis would you be charging me differently based on the different wards that I'm staying in? We talk about the example of a cotton bud or a PT service, a physiotherapy service. And they would say that they would accord priority to you first when they provide the service. But I am not too impatient. I don't mind being given priority or not. So I don't need you according me priority. I don't want to get a physiotherapy exercise, and you're charging me several $100s or even more for a PT session. So, Mr. Fong, there is no point in discussing this further. I am going to move some CSAs. Well, I will be moving CSAs in the name of Tommy Zhang. Well, they are shortchanging you, right? They are asking the doctor's representative to be here to engage in filibustering. We've been shortchanged by the private hospital for several decades. So if they come forth to filibuster again, well, let them be. They want you to procrastinate on the matter, right? And also, you said that well, doctors employed by the hospitals come with price transparency, but those who are not employed by the hospitals, then it's difficult for you to ask them for a full price list. I think this is outrageous. Whether you work for the hospitals or not, you are employees of the hospitals, they should have full price transparency. Whether they are working for the hospitals or they are freelance doctors, then they should be open about their pricing. Well, if that's the approach, then all doctors will become freelance doctors. So I think you haven't answered my questions, and you have not addressed our concern about price transparency. Every doctor should come up with a full list of their pricing. Well, you can, say, charge $100,000 a night for first-class ward. You can charge $50,000 per night for a second-class ward. We don't mind. The doctor representatives have been talking about supporting free economy. I don't mind that. But don't tell me that for a cotton pad or bud, you'll be charging differently because you live in different wards. Well, the pricing should be the same. The same bowl of porridge, for the same bowl of porridge, you will be charging differently for patients staying in different wards. This is something very basic. Private hospitals and private doctors are making huge profits. You don't need to discuss them too much. It's not a difficult issue to tackle, right? Thank you, Chairman. Thank you, Member. Whether it's the resident doctors or non-resident doctors of the hospitals, they have to fill out the items in the budget estimate. So both types of doctors are required to do that. So that's the first clarification that I'd like to make. Now, the members' concern, as I said, we are dealing with it right now. We would be communicating with the relevant stakeholders, the patient groups, private hospitals, and other stakeholders to put forth the best approach to deal with your concern. I have looked at the figures myself. I share your concern, and I've discussed with my colleagues as why the approach is being dealt with so strange. Well, Mr. Fong, you call it an interesting phenomenon. Well, it's not interesting. Now, if you are a patient lying on the hospital bed, then there's no choice. I mean, you can't do anything else but apart from signing onto the documents. Well, maybe the patient is in the pajamas and you are a patient and you are bound to sign anything that you're asked to sign up. Well, for several decades, we've been shortchanged, and how much longer should we be putting up with this? Mr. Tommy Zhang, you can have a third round. Thank you, Chairman. Mr. Fong, it's very simple. Now, well, why have I repeated my questions? Say, if you say that you've discussed with this and the government is agreeable to your suggestions, and we are talking to the hospitals to come up with a proposal which is agreeable to all. Well, maybe they don't agree to your proposal, then I will move a CSA. But I will not do it hurriedly. I will not like to be criticized by the law draftsman or the legal advisor on my CSA, so I will work on it very carefully. But the government must have its own stance, right? Now, you must start out your stance clearly to the private hospital. You may think that I am a disgusting figure. If you don't do it, then I will work on it. And it has to do with the 7 million people in Hong Kong, whether I can afford it or not. I don't want to be shortchanged. Maybe I can't afford to patronize a private hospital now, but maybe 10 years down the line, I can use one, and I shouldn't be shortchanged. And you try to feign that you already have price transparency. And maybe you can't convince the private hospitals, and they should give a full list of the pricing before I am admitted to the hospital. And they will say maybe they will give me the price of $1,200 for making a rounds and $48,000 for operating on you. No, I'm not talking about the budget estimate. And maybe I was I was about to be operated on, so I would sign on everything that you asked me to. What I meant by price transparency is that every doctor should be asked to give a very detailed breakdown of all the items that they will charge, be it the surgery cost, the cost of making rounds in the ward, and it should be in the list. All these items that should be in the list. It should not be the average figures that the hospitals are giving. The doctor's fees for every item, whether it's employed by the hospitals or not. It's not about the budget estimate or quotation that is going to be given to you. I'm saying that the prices or the fees for the different items should be put there up front on the website before the patient is admitted. So all these prices for the different items should be laid out clearly on the table for everyone to see. So, Mr. Fong, as I said, we will be meeting with you separately, but please get prepared for that. But if you do have a response now to Mr. Zhang, please do so. Thank you, Mr. Zhang, for your concern. Under our pilot program, we have asked the private hospitals to upload their price schedule, and they should also be displayed at the hospitals, and you can also ask for a copy of the price list of the hospitals yourself. Now, as to how detailed it gets to, the first step that we are asking is that they should come up with a price list for the different types of wards. So, or the general wards, and at least then we can make our own comparisons. Now, after the bill takes effect, then this will become our statutory power, asking the the hospitals to do that. Right now, it's on a voluntary basis, and as time goes by, as we gain more experience, it will become a statutory requirement. We want to do more on that. Thank you, Chairman.
Ms. Helena Wong? Well, I think we don't have the patience to wait, like Mr. Fong, wait for voluntary compliance and then making it a statutory requirement. I think it should be implemented as soon as the bill comes into effect. The government needs to take a strong stance and protect the public interests. We need to stop private hospitals linking medical services to the ward. We need to delink. That is the principle. Now, even though Chairman says that we have a private discussion, but I think we need transparency. We can discuss in private, but whether it should the fees should be delinked from the ward, shouldn't we hear from deputations, people who have experience in private hospitals? They have experienced the fee structure, and invite different so-called stakeholders. They can express their views. We shouldn't have it discussed behind closed doors. Mr. Fong, you cannot have a successful negotiation with the private hospitals, and we don't know when we will get the statutory requirement. So, Chairman, could you consider, regarding the fee structures, transparency, and delinking, could we hear from the public or hear from private hospital representatives? We need to have everything debated in open under the sun. Otherwise, we have to wait for your discussions, and do we have to suspend the bill and wait for your negotiations? Well, just now I said that I'm not saying we do it in private. I just want to have a meeting after a face-to-face talk after the meeting. It's not being done in private. It's going to be outside of the meeting. So as I previously dealt with Mr. Siu Ka-fai's concern about the beauty parlor, the beauty industry, it's because we have limited meeting time. If we just deal with one topic, and it's impossible so I will make good use of time, and then I will have the government to make arrangements. We can meet outside the Bills Committee, and in our next meeting we can follow up. Well, we have backtracked today. We were on clause 64. We're now backtracking to the clause 50 plus. So it doesn't mean that we cannot revisit the issue even after the Bill Committee has completed its work. I'd like to make good use of time. Ms. Zhang Laiwan has the third round of questions, and Mr. Tommy Chung has the fourth round. So regarding fees, I'd like to come back after our discussion outside the meeting, and then we will continue our scrutiny. Well, I have a lot of questions, Chairman. I don't mind whether we have separate meetings, because I understand it's hard to secure a meeting venue. So if members are interested, they can follow up. I think that's feasible, because we only have 2-hour slots. It's not enough to ask all kinds of questions. I want to ask these licensed businesses in the future, who is the beneficial owner? Who is the majority owner? Is it the licensee, the CME, the COO, the doctor? Who has the largest beneficial ownership? Let's have the secretary. Well, according to our bill, now each different licensee, the CME or the other related people, their functions and roles, liabilities are stated. We do not mention ownership. That is not what the bill deals with. So the actual beneficial ownership, it would depend on the company design. If it is sole proprietor, they are the CME, the practitioner, and so on. That's very clear. If it's a partnership, if it's a company, there will be a board of directors. They will be responsible for all the operations. So it depends on the circumstances. Well, but then it's a limited company. Do you understand? So you tell me, the licensee's responsibility, what are the risks? The license might be suspended, repealed. Well, if there are misrepresentations, fraud, and so on, they might be breached to different parts of the ordinance. So now the question is, who is breaching the law? Is it the company limited? It's a shell company. We're not referring to the people inside the limited company. We're not saying, Mr. Chan Hang Ban, we now have a limited company. We haven't reached that yet. In Clause 94, we state clearly the body corporate members, the body corporate, and the offenses that they can commit. So if the offense is committed according to Clause 94, the people could be it might be the company secretary, the major officers, silent partners, and so on. They will all have criminal liability. It's not just the limited company. Well, what about? Can we have a silent partner being a limited company? Let's say I set up a healthcare facility, and then I use company ABC to hold ownership of the healthcare facility. Can I do that? I can. That is a regulatory issue under the company law ordinance. Ms. Jiang's concern is that if a company holds the healthcare facility, so could that be dealt with under Clause 94? Could you explain? Well, allow me to read the whole Clause 94 for you then. So, if the offenses are committed under the ordinance, and the offenses by bodies, corporate, or members of unincorporated bodies. If an offense under this ordinance is committed by a body, corporate, or by a person as a member of an unincorporated body, and it is proved that the offense has been committed with the consent or connivance of, and so on, we said that that is the designated person, including the body corporate, the board of directors, the company secretary, the major officers, the shadow director, the company secretary, principal officer, manager, or any other person concerned in the management of the body corporate. So it tries to cover all the relevant people. And if it's an unincorporated body, a partner or office holder, a member, manager, or any other person concerned in the management of the unincorporated body. So this has listed all the possible people. They have been included, and they have to, if they breach this ordinance, they are liable. So we do include the people, individuals. Okay, now I just want to ask, can we regulate that the licensee also purchase insurance? Because you require the doctors to purchase professional indemnity, so the licensee, are they required to purchase indemnity insurance, Dr. Chu? Thank you, Chairman. As far as I understand, the law does not require that. Even the medical council does not require doctors to purchase indemnity. Well, if they can foot the bill, they have to foot the bill. So, how serious can this be? A lot of the members of the public, they encounter medical incidents, and a lot of times when personal reputation is at stake, when the career is at stake. So the doctors involved in medical incidents, it might be just a matter of carelessness, but in the future, if we have a licensee running a facility, and if there is no individual participation, and then if there are medical incidents, we don't know who is accountable, who is the final beneficial owner. There are a lot of uncertainties. In the last few decades, a lot of patients run into a situation where a family member may have deceased, or the courts might rule so-and-so be imprisoned, but there's no compensation. No compensation. That person might be, the deceased might be the breadwinner, they have the elderly and the young children to look after. So, if it's an individual, you require doctors to purchase professional indemnity. I think 90% of doctors, or even 100% of them, have purchased indemnity insurance. Do you know? We believe the majority of them have purchased indemnity. So these companies, are they required to purchase insurance? There's no requirement. Why don't you require them to do so? We don't require doctors to purchase indemnity either. Well, do you know why they purchase insurance? It's because it's an individual. The individual, they have property. That's his own asset and property, bank deposits. But if it's a limited company, there's no individual. They tell you there's limited liability in a limited company. Your personal reputation is at stake, but a limited company, if their registered capital is just $1 million, the maximum they can compensation they can provide is $1 million. Well, we have overrun So perhaps you can give a brief response whether you will consider Ms. Zhang's recommendation, and then I'll hand it over to Mr. Tommy Zhang. We understand members' concern. I think this bill is trying to safeguard Hong Kong public, especially the patients. We are not trying to deal with civil cases. This is not what we're trying to do. We have to separate the two ideas. Mr. Tommy Chung? I respect Chairman. I don't want to continue on the fees, but then Mr. Fong said his attitude is that all the prices are transparent. I'm not talking about general or ward. The thing is, we have different grades of wards, different rooms. I'm not saying whether you have listed the price of these awards. I'm just saying, why are there different price levels for the same service? I'll have to come back and ask this question. And to follow up on Ms. Zhang's question, from start to end, she has been direct and has been saying, you're saying this is not a civil action, a civil case. She's not talking about a civil action. She's just saying that when there's a patient is being treated by a doctor, is suffering from professional misconduct, there's professional negligence, then because we're now working on this bill, are we giving healthcare facilities or private hospitals, especially they limited companies, if we do have doctors' negligence or misconduct leading to the compensation claims on the patient's side, can it be pursued under this bill? I don't think so. But your response is that if I go to a clinic
and see this doctor, and I'm then admitted to a hospital, and maybe he performs a surgery on me and he has a failure, I don't think the doctor will escape scot-free, or the medical clinic will be scot-free. But then, going by what you said, maybe I have missed some part of your answer. You seem to be saying that because there is this licensee for this medical clinic, then the licensee would be held liable. But then the licensee may not be a doctor. I'd rather have the doctor be held liable, because the license of a doctor is very precious. So the focus should not be, say, to let the doctor go scot-free if he has a failure or he's involved in medical, he is professionally misconduct, then he must be held liable. Now, it should not be the case that if they say 4 or 5 of them band together, then they can go scot-free, and then they may establish a limited company based on a capital of $100 million, and then that would be the amount of compensation to be paid to the patient. Mr. Chang, Tommy Zhang, you have understood it correctly. Whether we have the bill or not, if the doctor is engaged in certain misconduct and there needs to be a compensation, then that can be, the compensation will be given out, and that's the existing practice, no matter whether he is the CME or not. But if he is a CME, then there will be an additional layer of responsibility. I would like to ask you, in a medical clinic, maybe this doctor is one among a group of doctors. So if we have the bill, does it mean that he will be taking insurance of a lesser amount No, that will not be the case. The individual doctors will take out their own insurance. But then you said that if he is a CME of the medical clinic, then he would take on additional area of responsibility. Say, if this person has to take responsibility for this bill, we are talking about areas outside of medical procedures. We're not talking about, say, failure in surgery. That has to do with the Medical Council of Hong Kong instead. So the chairman, you have been right. The bill has an additional requirement, and the doctor has to be actually responsible for the patients. This remains unchanged. That's the present practice. But then for the operation of the clinic, that falls under the responsibility of the CME. So the CME has this additional responsibility to make sure that the clinic's operation meets with the DH's requirements to safeguard the patient's safety. But then that's the additional responsibility. But in relation to the patient-doctor relationship, that remains unchanged. So whether it's Dr. N. Zhang or Mr. Tommy Zhang's questions, the focus is really on the handling of medical incidents. Now, as far as that is concerned, the original protection afforded to patients will remain unchanged. It's just that the bill will add an additional layer of safeguard, and that is in the operation of the healthcare establishment, there will be another level of management, and it will be supervised or regulated. I understand that, but the chairman, his answers seem to be inviting more questions from us. Maybe I'm old, maybe I misheard him. He seems to be saying that there are two layers of protection. Say, if I go to this medical clinic and Dr. A has failed in my surgery, I claim a compensation from him. I can't claim compensation from the CME, right? Now, I can pursue compensation from the doctor. I can't pursue compensation with the CME, right? There will not be two layers of protection for me. Is that right? Maybe in the medical clinic, there may be personnel who are not doctors and have committed mistakes. Then the CME will have to be liable because he is a person who is supervising the clinic's operation, right? Yes, Mr. Tommy Zhang's understanding is correct. The patient can also complain about the CME and the licensee if he thinks that the clinic is not operating in a reasonable way. And as far as compensation is concerned, it should only be done. The compensation should only be asked for of the doctor concerned. Let's move on to clause 65. Dr. Enchang, maybe you can try to pursue my questions further with the administration. Please ask my question on my behalf. I'm the chairman. So can I ask the administration to give you a written reply? And after Dr. Zhang has read through the reply, and if you think there is further need to follow up, maybe when in the meeting plan to talk about pricing, then Dr. Enchang can join that meeting and further discuss this. I have another meeting to attend to. I still have further questions to ask. Now, the doctor used to have very clear responsibilities, but then we talk about the CME, the licensee, doctors, and there are so many parties involved. And I'm just worried that the responsibilities of the different parties get mixed up and confused. I know that Dr. Zhang is very concerned about this. I would ask the administration to give a very clear reply, and I would also be pursuing on behalf of Dr. Zhang on this issue. So 3 questions from me. Can you give me a written reply? The legal advisor has something to say on clause 64. Dr. Chiu just now talked about the licensee handling the complaints, and that the time taken to handle the complaints will be governed by the codes of practice. It will not be detailed in the bill. So can the government say something more on this? On the licensee handling the complaints, what is your thought? What is the period for handling the complaints? So what is the time allowed for them to complete the handling of a complaint? Dr. Chiu. Well, we will ask them to come up with a reasonable period to do so. Under the code of practice, maybe we cite an example, 10 days. We understand that say for individual hospitals under the HA, the period allowed for handling complaints is around 6 weeks. So PHF will be required to specify a reasonable period to handle complaints. We have to be mindful about the types of institutions. Maybe hospitals need more time because it's more complex, but then for clinics, they may need a shorter time period. So we have to look at the individual premises, and we have to allow some flexibility. But in any case, we'll be mindful that they are reasonable. Now, the legal advisor is talking about subsection 4, but in terms of the time allowed for handling complaints, it's not written into the bill. Would you be writing that into the bill, or would you be including it in the code of practice? Dr. Chiu, the time for handling the complaints, or the period for handling complaints, we will not put a specific period there, but later on we will further discuss the complaints committee, and for the complaints committee, there is a specified period. Well, it means that the period specified there is 2 years. You think 2 years is reasonable? You talk about complaints. I'm not talking about handing down a ruling or decision. Maybe we can further discuss later on. 2 years. And the legal advisor was asking, why couldn't you write that in here? Why you don't want to specify the period here? I'm not happy with codes of practice. And maybe they would be presenting us with the codes of practice at a time when we are very busy and we don't have time to look at it. We refer to 2 years. What we meant by that now the complaint has to be lodged within 2 years after the incident has happened. Now the legal advisor's question was not this. She was talking about the time taken to handle the complaints, and Dr. Zhu said that, well, it depends on the different circumstances. Maybe private hospitals are more complex in their operations, so we may have to allow them more time. But when we talk about daycare centers and clinics, the time period may be shorter. So in the codes of practice, we would set out all these. It's not that we don't want to give the information to members, because we used not to regulate the daycare centers. So after implementing the ordinance, we'll have to gather actual experience, and then we can come up with a reasonable time period for handling complaints. Any further follow-up, legal advisor? In clause 64, Clause 4, the chairman said also the chief executive CME of the facility must provide to the director a summary of the complaints. So is there a time limit for that as well, Dr. Chiu? According to present practice, that has to be done on a monthly basis, every month. Well, why don't you write that into it? You want to include it in the code of practice. Well, the present practice is that it is a requirement in the code of practice. What's the difficulty of putting that in here, Mr. Fong? The present practice is that it is being treated or it is included in the code of practice. We just want to abide by the present practice. We do have the CAP 165 and 343 to govern the relevant issues. And the arrangements have proved effective. And as far as daycare centers is concerned, maybe we need to adjust the timing as well, because there is a new type of establishment to be covered. Any further follow-up, members and legal advisor? If not, then Clause 65 then. Clause 65 sets out that if a complaint against a private healthcare facility is made under Section 82 and the Complaints Committee is considering the complaint, then the facility must fully cooperate with the Complaints Committee, and the facility can also try to reach a settlement with the complainant. As to the composition of the Complaints Committee, we will further discuss that later on. This section is about the PHF having to cooperate with the work of the Complaints Committee. On this particular clause, any question? Now, if a complainant complains against a certain PHF, and then he complains also against the lodges complaints with the Complaints Committee, and if there can be a settlement, then we may be reaching the rule that the witness should not be approached.
So let's say a person has lodged a case with the police and therefore you cannot tamper with the witnesses. Well, we're talking about complaints against an institution. So first of all, they have to lodge a complaint with the institute. If there's no satisfactory response, then they would approach the complaint committee. We're just saying here that aside from encouraging private health care facilities to cooperate with the complaints committee, we also encourage the institute to do their best to give a satisfactory answer to the complainant. So they can seek resolution, but it does not deprive the complainant an opportunity to complain. If the complainant feels that it should be followed up by the complaints committee, they do not need to withdraw their complaint. And when we reach the complaint committee clauses, we can elaborate further. Any further questions? Legal advisor? Legal advisor? Chairman, in clause 65, it requires the institute to fully cooperate with the complaint. The facility must fully cooperate with the complaints committee in providing information or documents. If they don't comply, what are the consequences? Mr. Lee, thank you for the question. Well, a lot of our clauses deal with private healthcare facilities. When they apply for a license, they have to comply with the different clauses. So if they don't keep records, complaint records, or if they have not set up a complaint handling procedure, that reflects on whether they are a reasonable institute to make an application for a license. So if they don't cooperate, that might be a breach of, and that might be a reason for the Director of Health to consider whether they are reasonable institute facility to apply for a license. Well, I also want to follow up on the response just now. well, if the facility doesn't provide documents, then they therefore not be a suitable person to apply for a license. They might have their license disqualified, repealed. Well, what if they change the name? They change the applicant? Well, I think in the restaurant business this occurs as well. How will you deal with that, Mr. Lee? Thank you for the question. In our licensing regime, we added an extra layer of protection. To set up a medical facility, compared to the current arrangement, we have an extra layer of protection. So we have requirements regarding staff, medical equipment, management, before they can receive a license. So compared to the current situation, we have an extra layer of supervision of premises, so it protects consumers and patients more. So they have to go through so many loops to apply for a license. So for a person who wishes to operate a healthcare facility, there is some deterrent effect. Ms. Zhang Laiwan. Well, let's say you're a licensee and you are registered as a limited company, and then if the license is repealed, they just set up a new limited company. We understand your concern. You have to understand that in actual operations, if the license is disqualified, they would have to stop renting the premises. They have to make a new application. When they make a new application, it takes time. So operations will have stopped for a certain period. So there's no incentive to not comply with and to therefore have their license revoked. So the whole idea is that we require the licensee to satisfy the ordinance requirements. For example, if you have to cooperate with the complaints committee, if you don't comply, well, there's no incentive for them to not cooperate because their license might be revoked. The consequences are significant. So we don't see if they want to run a business, why won't they comply? So that comes back to people who get the license and operate a business. They of course want to succeed, but it's still a business, and now it's purely a business. I feel that previously doctors had their reputation at stake, and when there's negligence, they are sentenced. I feel sorry for them. They're not just paying compensation, they lose their reputation, and if their licenses are revoked, let's say 6 months, a year, they have to shut down their clinic. But having a limited company acting as a licensee, and in the future we will have patient A suing the dentist, and that would be a suit between the dentist and one patient. You're not affecting the company operating the licensee. You can take them to a medical council and so on, and they can still continue their business. So I can't wrap my head around one thing, is that in the past we had a doctor's reputation at stake, and now we have a limited company. So we don't know who's responsible, and we ask if there's any. Can they have patients to sign consent forms or disclaimers? Ms. Zhang, You have raised this question before. We already agreed on how to deal with it. So Mr. Fong has something to add. I think Ms. Chang has some misunderstanding. We're not saying that this ordinance is changing clinics or private hospital or medical facility. Private hospitals, we don't have an individual licensee. It's still a company, and the majority of clinics are operating as partnerships. So the ordinance is not urging them to set up a limited company. So daycare centers or clinics, if we can continue as an individual licensee, there is no incentive to change the ownership structure. So you can communicate with Ms. Chang after the meeting and resolve her questions and doubts. If we can move on to Clause 66. Part 5, Division 6 runs from 66 to Clause 66 to 70. And we have some miscellaneous operational matters. Clause 66 deals with distinct and separate premises. So the operator of the facility must ensure that the premises of the facility are physically separated from any premises that serve a purpose not reasonably incidental to the facility that is an exempted clinic. So that is Clause 66. Any questions, legal advisor? So now we can deal with another clause. Clause 67 is about a separate entrance. So in addition to the requirements in Section 66, the operator of the facility must also ensure that the facility has a direct and separate entrance not shared with or involving passing through any premises that serve a purpose not reasonably incidental to. So we heard that we need some transitional arrangements to meet the requirements, and the government is dealing with this, and in the CSA stage we can have further discussions. Legal advisor? Anything from the legal advisor? No? Well, it's almost time, and we conclude at Clause 67. We'll start at Clause 68 next meeting, and there's no AOB next meeting. Let me announce the date. It will be 23rd of April, 10:45 to 12:45. And the 14th of May, 4:30 to 6:30. I hope you can set aside time. If we don't have any other business, we conclude the meeting. Thank you.